Am I able to share my screen? I can. Okay. All right. Welcome, everybody. My name is Mike Liberto. I am the president at Trico Title Agency. And thanks for joining us today. We're going to spend some time talking about title insurance. I know, super exciting. You know, if we were doing this in person, as I've done the last couple of years, I would ask our participants to basically ask questions as they think of them. And so I don't see that this is any different. So if you see something or hear something and you have a question, feel free to interrupt me and ask the question. You know, that way we can hopefully get it answered and, you know, not lose sight of the fact that you had a question. So we will also be taking a break at about halfway through the presentation, just because I was originally asked to, you know, come up with about 2 hours worth of material, and that's a long time to be, you know, sitting listening to me just talking. So with that said, here we go. So I like to start this out with some true or false questions. In fact, you know, maybe some of you, if you want to pipe in either by the chat or just, you know, by unmuting yourself, feel free to answer them. So here's the first one. Title insurance companies search the entire chain of title in the public records for the property. Is that true or false? It's false. So underwriting search standards for residential properties require a title company to search back to the last good warranty deed and purchase money mortgage in the chain of title, meaning basically those recorded at the same time, or to two warranty deeds between unrelated parties, as long as they're recorded more than 2 years apart, or to the date of a prior owner's policy, or 40 years. You don't need title insurance because there are no claims ever made. Is that true or false? That is also false. I just found this last night. According to the American Land Title Association, over $409 million was paid for claims in the first quarter of 2020 alone.
So what does that mean?
That means that there was
does that mean paid to property owners or paid to their attorneys?
Well, no, it was well, it could be both, but it's basically claims that are made on either owner's policies or loan policies, and it probably includes defense costs, but still, for, you know, one calendar quarter, that's a lot of money. Next, you have to order title work from the same company in order to get credit for a prior policy. That is false. Reissue credits are available regardless of who issued a prior policy. Now, it's actually a trick question. For residential properties, a prior policy no longer results in a discount. Premiums are discounted if the seller bought the land from an unrelated party in the last 2 years. Now, reissue credits are still available if you have a prior policy for commercial properties. You don't need a survey of the property if you have title insurance. Is that true or false? That is both true and false. A survey is not required to get survey coverage under a homeowner's policy. And we'll be talking about these a little bit later on today. because a homeowner's policy is different from an owner's policy. A survey may not be required to get survey coverage under an owner's policy if the seller signs a detailed affidavit. Survey coverage is provided under loan policies without a survey under certain circumstances. But this is a survey of a commercial building that we did a closing for, I want to say 2 years ago. And if you notice, in green near the top, they indicate an easement for a water main. And in red, about in the middle of the building, they indicate an easement for sanitary sewer. What this is showing is that the developer had built the building over utility easements. Now, the good thing, but the beneficiaries of those easements could, if they want, builder, the owner, to let them lay the utilities underneath the building. So we basically went back to the city, got those easements abandoned. Now, no one would ever know this without a survey. So to me, and I do a lot of public speaking to lawyers, I always tell them, and in my opinion, if an attorney doesn't recommend to their client that they get a survey, I think that's malpractice. So I always think it's a good idea to get a survey no matter what. Next, true or false? I am still covered by my title insurance policy if I sell my property.
I have a question. Do you think it's a good idea for homeowners or just mostly commercial for surveys?
I think it's a good idea for everybody. and here's why. Particularly in Grosse Pointe, there's a lot of houses where they have detached garages, and many could be built within easements that run along the back of their property. You also see a fair number of issues coming up with driveways being on neighbors' property. So for the $300 or so that it would cost to get a survey, if you're the buyer, I think it's a good investment.
I know this is kind of more legal, but then what about the like the right of use? If you've used it for over, I don't know what it was, 10 years or 15 years, it's basically yours.
Mm-hmm.
Or well, that's just another.
Yeah, sort of like the adverse possession,
right?
Acquiescence. Yes, but the problem is that you have to then, go through the nightmare of the litigation to get a court order to establish that, and it's not cheap or quick.
Okay, thanks.
You're always, I just think you're better off knowing, I mean, if you could get a survey, see that your garage is 6 inches into the, the utility easement in the back, and make the decision that, hey, DTE is never going to come through and bury all these electric lines, right?
Yeah.
But at least
Okay, thanks.
Okay. So getting back to this one, I'm still covered by my title insurance policy if I sell my property. This is also true and false. If you have an owner's policy, you'll still have coverage if you give a warranty deed. You'll lose coverage, however, if you record a quitclaim deed, with a couple of exceptions. If you have a homeowner's policy, your coverage will continue. So let's talk about title insurance itself. A title insurance policy is basically a contract that reimburses the insured for losses that are caused by specified title defects. Now, title insurance, unlike almost all other types of insurance, insures against past problems. So, unlike your auto insurance, which will insure you if after the effective date you get into an accident, title insurance insures against things that happened before the effective date. Each title policy has an effective date, and the policy ensures the title is, as stated on that date, and insures against matters that were created before that date.
Question.
Yes.
Does gap coverage have to be specifically stated, or is that inherent these days in policies, or if a policy is issued right at the table?
So if a policy is issued at the table, you're probably getting coverage through the closing date and not through the recording date. If it's issued after the recording of the vesting deed, it's pretty standard that you're going to get coverage through the date of recording. You know, title companies are just used to doing it that way. I mean, I don't know of any title company that would refuse to insure the gap.
Thank you.
So subject to, you know, the policy's exclusions, exceptions, conditions, etc., an owner's policy will insure against loss or damage because of title being vested other than is stated in the policy, meaning if it turns out that somebody else actually owns the land, any defect or a lien on the title, unmarketability of the title, and a lack of right of access to and from the land. A lot of people aren't aware of that it ensures access. Now, exceptions, each owner's policy will have specific exceptions from coverage. It's basically things that are a matter of public record, such as easements and building and use restrictions. Each owner's policy also will be subject to the so-called standard exceptions, and those include parties in possession, encroachments, overlaps, boundary line disputes, things that would be disclosed by a survey, easements that are not in the public records, water, mineral, oil, and gas rights, basically construction liens. Now, as you know, these standard exceptions are usually deleted, and therefore those matters are insured if the title company gets an owner's affidavit and a survey. So here's the type of risks that are insured by a title insurance policy. And these are some common defects that you get coverage for. Surveyor's errors, fraud, forgery, expired powers of attorney, title examiner's oversights, recording and indexing errors, missing heirs, unprobated wills, believe it or not, deeds by minors. We do see people putting their minor children in title with them, and then when they go to sell or refinance, they're caught by surprise when we tell them you have to go get a conservator appointed for the child. Deeds by incompetent persons. You know, a good title closer will, you know, recognize if somebody, you know, may not have the mental capacity and will ask questions to determine if they have the mental capacity. Lack of a right of access. Let's see here. And then transactions by unauthorized individuals. You know, so that's why you'll see a title company, if there's a corporation or LLC involved, you know, asking for board resolutions or operating agreements.
Questions?
Yes.
One of the things that you had mentioned in terms of the unmarketability. So if there is something on title and you say, well, we can't sell it with this, it's not marketable, and so we contact our title insurance, when is it determined whether it is unmarketable or whether it might be an effect on price but doesn't make it unmarketable? I mean, how does the insurer, not the agent, but the insurer actually deal with that?
You know what? Very good question. And I'll be honest with you, I don't know, because I've been doing this a long time, but I've never seen a claim based on unmarketability of title.
Okay. And then the second one is on the survey. So errors in the survey. Can you talk a little bit about surveyors who have differences on their documents in terms of what was measured versus what was recorded? Is
Mhm.
that standard in the survey industry? Would that be, you know, leading down the area of error, or is that out of your expertise?
No, that's not really an error. That's more of, if you were to ask 5 surveyors to survey the same piece of property, you'd probably get 5 slightly different descriptions, assuming it's a meets and bounds description, just because, in part surveying is, not all science, but somewhat an art. They're using their equipment to look at the property lines and making a determination as to how many minutes and seconds and feet and hundredths of a foot. So
And where to put stakes?
yeah, so it's not unusual to see a historic recorded legal description, and then somebody hires a new surveyor who goes out and puts boots on the ground and surveys the land and comes up with some slight differences.
Sure.
Not unusual, but that really doesn't affect whether or not a transaction can close or not, because as long as the surveyor is certifying that legal description to the title agent and the underwriter, you're going to
That's all they
insure.
want.
Yeah, you're going to insure based on both the recorded and measured descriptions.
Okay. Thank you.
Yep. Okay. Title insurance commitments. Now, a title insurance commitment is basically an offer to insure title to the property if requirements are met and subject to certain conditions. It will reflect the status of title to the property on the effective date of the commitment. It will include requirements for obtaining a title insurance policy and exceptions to coverage under the title insurance policy when it's issued. So there are several matters to review when you receive your title insurance commitment. So the first thing is to look at Schedule A. It'll show the effective date. Now that effective date is not the date that the title company produced the commitment. That's the date that the Register of Deeds is telling the public our records are up to date as of this date. So right now, Macomb County, their effective date is probably just a few days off from today. When the pandemic struck, Wayne County for a while was not processing any recordings. So I believe their effective date is, they're a few weeks off. They did start processing recordings, so they're catching up, but still, it wasn't as good as it was pre-pandemic. It'll indicate the type of policy to be issued and the amount of coverage. It'll show the proposed insured, which should be your buyers on your purchase agreement. It'll almost always show that the interest in the land that's going to be conveyed is fee simple, and it'll show who the current owner is. So here it's showing that as of the effective date, John Smith owns the fee simple interest in the land. And then it'll give the legal description. So it's always good to take a look at that and make sure that it's accurate. So let's talk about requirements. To me, this is probably the most important section of a title insurance commitment. As one of my colleagues once said, these are requirements, they are not suggestments. So, the first requirement will be to record the documents necessary to issue the policy. So record a warranty deed, record a mortgage if a loan policy is being issued, recording a discharge of the owner's existing mortgage, provide evidence of payment of taxes that are due. It's a requirement that the seller be paid the purchase price, or that the lender issue the loan proceeds. Of course, it's a requirement to pay us, and it's a requirement that you tell us if there's somebody who's going to be in title or who's making a loan that we're not aware of, and then we may make additional requirements. We ask that you verify the legal description if a legal description was not provided. Understand that title companies basically only search the legal descriptions that are provided to them. They don't search surrounding properties to see, well, maybe if the seller owns other property. If there's a manufactured or mobile home on the property, that we ask to be notified. We require an owner's affidavit. And we ask to be notified if it's commercial real estate, because commercial real estate brokers have lien rights for their commissions.
Question.
Yes.
Does the owner's affidavit just benefit the title firm or also the buyer?
It really just benefits the title insurer. What it's doing is it's providing information, in the form of an affidavit, as to things that are not in the public records. So, for example, who's in possession of the property? Has there been any work done on the property? That's important because contractors and suppliers and laborers have 90 days after the date of last work to record a lien.
Sure.
And so they may have unrecorded lien rights. So that's why the title companies ask that, so that they can then give the coverage to the buyer. So I suppose the answer is really it does benefit the buyer, but indirectly, because it will then get better coverage under the title insurance policy.
Thank you.
Okay. Next, other types of liens to be discharged. There could be federal tax liens, state tax liens, unemployment insurance agency tax liens, judgment liens, condo and subdivision association liens, and as we were just mentioning, construction liens. Other requirements that you may see is you may see something that says, record evidence eliminating the interest of, Jane Doe. Recording a certificate of trust if the property is owned in the seller's trust. Again, that goes to authority issues. There may be the same requirement for a borrower if they're borrowing money and properties in their trust. We may ask for the last 4 digits of a party's social security number. Particularly if you can imagine if we're asked to insure a property that's owned by John Smith in Wayne County, and we search the names, we're going to come up with a lot of John Smiths. And I can assure you, there will be tax liens, bankruptcy filings, etc. So it's not uncommon for a title company to ask for the last 4 digits of a social security number. We ask for closeout letters for revolving lines of credit. The title industry a number of years ago ran into some issues where parties were paying off the mortgage, selling the property, and then all of a sudden the buyer would be notified by a bank that, hey, the loan that secures our mortgage is in default. And the buyer is saying, well, what do you mean? Well, it was a revolving credit line and they never closed it out. So you had sellers around the country, paying down the line to zero, and then running it back up after they sold the property. We'll provide a note if there's liens against the buyer. Now those liens typically don't have an effect on the mortgage because it's a purchase money mortgage, but if there's a second mortgage, then it will have an impact. We'll ask for operating agreements of LLCs, resolutions of the board of directors of corporations, and we'll notify the parties if there's certificates of forfeiture for unpaid real estate taxes. So then these are the sort of typical exceptions that you might see on Schedule B2 of the commitment. So, you know, the first 5 are basically your standard exceptions that can get removed with the owner's affidavit and a survey. You will always see an exception for unpaid taxes. You know, typically then you'll see exceptions for either, you know, terms of master deeds, easements, building and use restrictions, things like that. Okay. So one of the things that I always recommend to parties, and I apologize, this is kind of hard to see, but to ask the title company for a markup of the commitment at closing. And what that does is it basically turns the commitment into a policy. You know, so it'll show, for example, that the effective date will be the date of closing or the date of recording of the deed, whichever's later. It'll show the buyer as now being the owner of the property. It'll remove, you know, the requirements, show them as having been met. You know, you will indicate, you know, the buyer's mortgage on Schedule B of the policy, and then it removes some of the exceptions. So always good practice to ask for that. Okay, let's talk a little bit about endorsements. But, you know, it's good to have a working knowledge of them. So title insurance endorsements basically modify or extend insurance coverage provided under the policy of insurance. There's 2 types of title insurance endorsements. There are endorsements which change the terms of the policy itself, such as defenses, exclusions, or terms and conditions. One real common one for commercial policies is they ask for a deletion of the arbitration provision. That's an endorsement that changes the term of the policy. The other is endorsements that provide affirmative insurance for specific items. Now, some endorsements are free. Others require payment of an additional premium. And we'll just cover a little bit some of the more common endorsements. The covenants, conditions, restrictions endorsement. This was sort of known as the comprehensive endorsement. It gives the owner insurance for loss or damage resulting from violations of building or use restrictions, the exercise of rights to remove minerals, encroachments, liens for private assessments like from a homeowners association, the existence of options or rights of first refusal. And now the requirements will vary depending upon the nature of the transaction, such as whether the land's improved or vacant or under construction. But a title company will typically want to review a survey and the building and use restrictions that are recorded. The survey endorsement, this is really best suited for land with a meets and bounds description. An access endorsement, probably the best time to ask for this is if the house is on a private road. A tax identification endorsement, I would recommend that if there's 2 or more tax parcels for the property, or if there's been recent divisions. So let's talk about title defects a little bit. Now, just as sort of a disclaimer, the information I'm about to present gives possible solutions to title defects. Now, in title insurance underwriting guidelines can be different amongst different title underwriters. So whether these techniques work for your particular title company will depend upon the facts that exist. So the first thing, and you know, just sort of a heads up, I mean, this stuff is pretty detailed and really getting into the weeds of title insurance. It was initially prepared to present to commercial real estate attorneys. You don't have to know all of it by the end of today. There's not going to be a test, but it's just good background knowledge to have in case your deal runs into an issue. You can say, hey, what did that guy talk about? Oh yeah, he talked about this. Maybe this will solve the problem. So the first is the mutual indemnification agreement. So at least 10 title insurance underwriters have, in the state of Michigan, have entered into a contract. It's known as the mutual indemnification agreement. And what it does is it allows title companies to insure over certain defects without having to go and request a specific indemnity from a prior title company. Now, understand that relying on an indemnity, you know, under the MIA or otherwise, it may allow your transaction to close. It doesn't clear up the chain of title. So there is still a risk of a title dispute due to the defect in question. So to rely
and then
on
there's no coverage for that suit because it was accepted.
No, there probably will be. The problem is that you're still going to have to, you know, basically waste time on the litigation. Even if the title insurance underwriter is paying you for your attorney, you know, you're going to have depositions and discovery and go to hearings and all that other nonsense, right? So to rely on the mutual indemnification agreement, a title company must have a policy issued by another insurer which doesn't have an exception for the defect in question. The policy either has to be an owner's policy insuring the current owner, or a loan policy that issued to a lender that either is in the process of obtaining or has obtained title, you know, by way of foreclosure or a deed in lieu. It has to be a policy issued by one of the parties to the mutual indemnification agreement, and it has to insure an interest in the land in the state of Michigan. The amount of the defect must be $500,000 or less. That was recently increased from $250,000. And it has to be less than the amount of insurance on the prior policy. Now, I have talked with some underwriters and they may not strictly enforce that requirement, and they may insure over the defect, even if the defect is more than the face amount of the prior policy. So only certain defects are covered by the mutual indemnification agreement, and they include, you know, an unreleased dower or homestead interest. Understand that Michigan land title standards regarding homestead rights and mortgages were withdrawn in the last edition. So you may not need an indemnity if a mortgage is signed only by a wife in title and not by her husband. It covers an issue regarding the proper release of a mortgage, a levy, judgment lien, attorney's lien, child support lien, construction lien. I mean, you name it, almost any kind of lien that you can think of. It covers a question of whether effective notice or due process was given in judicial proceedings, or failure to appoint a conservator or guardian. It'll cover a question of authority of a fiduciary to convey or mortgage the property, basically because they didn't say record the letters of authority in a probate case. It will cover ownership of land being vested other than as recorded. Now, it can't be relied on if there is recorded evidence of proceedings to foreclose or enforce the defects. So say there's an unreleased mortgage, you could use the mutual indemnification agreement to get coverage over that. But you won't be able to get it if there's something in the records that indicates, hey, we're foreclosing that mortgage. It can't be used to clear title if the defect is basically a revolving credit line or home equity line. it won't work if the mortgage was recorded within the previous 6 months. It also can't be relied on if the defect is failure to record a deed to a mortgagor and the lender's foreclosing or accepting a deed in lieu. Other defects, basically, you're going to have to get a specific indemnity from the title insurance company. Now, it's always good practice to get a prior policy from your client or another party to the transaction. If you can't get an earlier policy, a commitment may be helpful because your title company may be able to find a prior policy based on that commitment. So as you can see under the mutual indemnification agreement, the prior policy may clear up matters that are still of record. It can help the title company expedite the publication of its title commitment, because sometimes a title company can rely on a prior policy in its search and exam. And for commercial transactions, it can result in a lower reissue rate. All right, so I thought right now we would take a 5-minute break because we have more to go, and I know it can be painful listening to me talk the entire time. So 1:45, give you a chance to, get something to drink, return a call, something like that. Thank you. Okay, let's get started again. So other ways to cure title defects can be found in a number of different statutes here in Michigan. The first is the Marketable Record Title Act. And the bottom line for this act is that it basically states that a person has marketable record title under the act if there's an unbroken chain of title for 40 or more years and no one else is in possession of the property. So an unbroken chain of title exists if there's one or more transactions creating an interest in the land which have been of record for at least 40 years and there's nothing recorded purporting to divest that interest. So someone with marketable record title is not subject to any interest which is more than 40 years old if there's no recorded reference to the interest for the past 40 years and no notice of claim has been recorded. Now, the act does not extinguish all interest in land. Exceptions exist for the rights of lessors, lessees, mortgagees, certain easements and governmental entities. And note that title insurers will not rely on the Marketable Record Title Act to insure over building and use restrictions. Also understand that that is changing. There was an amendment to the Marketable Record Title Act passed last year, which would basically say that old building and use restrictions will go away if nothing's been recorded to renew them in 40 years. And it gave the public 2 years from the passage of that act to decide if they want to renew the building and use restrictions. This has been sort of a hot topic in the industry. There is currently pending in the legislature an amendment to extend that 2-year period to a 5-year period. As a lot of homeowners associations and others are trying to figure out basically if they want to extend the restrictions and what is needed to extend the restrictions. So I can tell you that the real property section of the state bar has come up with its own bill to further modify the Marketable Record Title Act, just based off of, what we at the real property law section saw as, defects, if you will, in the existing legislation. So there may be more changes to this law coming in the future. Affidavits. Affidavits can be used to cure title defects, and affidavits can be recorded regarding a number of matters. So birth, age, sex, marital status, death, names, residence, identity, capacity, relationship, family history, heirship, homestead status, and military service.
Question.
Yes.
So one of the things I've seen a few times, and maybe some others have come across it as well, you're looking at selling a property and the grandkid put grandpa's name on it or mom's name on it to get approved for a loan a couple of years back, and they're dead now. Their estate was never probated. Mm-hmm. Is that the kind of thing where affidavits can come into play in terms of heirship, or is that something where an estate would have to be open in order to get some type of terms?
It could be the type of thing where you use an affidavit of heirship. I've used them myself, did one recently. What the underwriters typically like to see is an affidavit signed by an uninterested third party who can say,
a family friend,
a pastor, family attorney, somebody like that. And then they sign an affidavit as to who the heirs are, and then ask for quitclaim deeds from all of the heirs named.
Okay. Is that something that most, or some of the underwriters will accept that?
I've seen a few different underwriters accept that.
Okay.
I think it's going to be fact dependent, right?
Sure.
It's one of those things where, say, somebody died 20 some years ago. The person they named as personal rep in their will is now, incompetent, things like that.
Right.
If it's, somebody recently passed away and the probate case was just closed last week, they may say, you know what, just go back and reopen it.
Okay.
Right. So, all right. So affidavits can be used to regarding existence of monuments and physical boundaries, fixing ambiguous legal descriptions, facts about who's in possession of the land. An affidavit can be used to demonstrate the authority of a buyer of real estate sold at foreclosure. Affidavits are used for lost mortgages, though there are specific requirements for affidavits of lost mortgage. Errors and omissions relating to the proper place of recording. Believe it or not, I've seen documents that were for land in one county recorded in another. Let's see here. And then Scrivener's errors and omissions. Surveyor's affidavits can be recorded. Surveyors can record affidavits to correct minor errors in a survey. Now, an affidavit can't be used, however, to modify the boundaries or shapes of lots or outlots in a subdivision. So in the absence of a recorded affidavit, a mortgage is considered to be discharged 30 years after the date of maturity, if that date is stated in the mortgage. So a lot of times, old unreleased mortgages can be insured over just based off of the statute. If the maturity date is not in the mortgage, then it's considered discharged 30 years after the date of recording. Oil, gas, and mineral leases. If a lessee under a forfeited lease fails to record notice of it, the lessor may notify the lessee and record an affidavit saying, hey, this lease is over. Dower rights. A woman claiming dower rights to land previously conveyed by her husband alone must do that within 25 years, or those dower rights go away. Defective.
Haven't they already?
Oh, I'm sorry?
Haven't dower rights already gone away?
They have, except in the case of if someone was married and not entitled to the property and the husband passed away before that statute was passed. They would still have dower rights. Defective conveyances. So if an instrument is given in good faith and for valuable consideration, it's not void, even if there's some defects in requirements regarding, its execution, its notarization, etc. Another curative statute is one regarding judgment liens. Judgment liens expire 5 years after the date of recording. Now, they can re-record a judgment lien once, but you can extinguish the judgment lien by recording a discharge, a certified copy of a satisfaction of judgment, meaning the judgment's been paid, a court order that discharges the lien, or a certified copy of a bankruptcy discharge, as long as that you include the bankruptcy schedule showing that it listed that debt. And then you can also record an affidavit by the debtor. Another curative statute has to do with construction liens. Basically, if a construction lien has not been foreclosed within a year, then it essentially is not effective. And so somebody who, after a year, has a construction lien recorded against their land, present an affidavit to the county clerk, and the county clerk is required to examine the records And if in fact there has been no lawsuit started, the clerk sends a certificate to the owner, and the certificate gets recorded. So let's talk a little bit about tax foreclosed properties. While you don't see a lot of it in Grosse Pointe, you certainly see a lot of it elsewhere throughout the state. So land that's been subject to foreclosure for unpaid real estate taxes frequently has title defects. A lot of those defects relate to the failure to provide constitutionally adequate notice to those who had an interest in the land. The insurability of tax foreclosed properties is determined on a case-by-case basis. It's essential to first examine the chain of title to determine who had an interest in the land at the time of the tax foreclosure. So it's not only owners and mortgagees, but also other creditors such as judgment lien creditors, the IRS, the state of Michigan. It's also essential to review the records of what's known as the foreclosing governmental unit. Sometimes those records can be easily obtained, such as in Macomb and Oakland counties. Other times, such as in Wayne County, we have to submit a Freedom of Information Act request. So the foreclosing governmental unit is essentially the county treasurer. So a careful examination of those records includes the type of notice, who received notice, when did a party obtain a record interest in the land, and whether there's an acknowledgement of receipt of notice and who signed that acknowledgement. Based upon a U.S. Supreme Court opinion in Jones v. Flowers, many foreclosing governmental units send notice to the taxpayers by regular mail if the certified mail is refused or not acknowledged. However, they may not send the additional mailings to mortgagees or other interest holders. It's going to depend on the county. Other factors that impact a decision to insure include the age of the transfer by the foreclosing governmental unit, facts regarding possession or abandonment of the land, the type of insurance policy being requested, and the amount of insurance being requested. If it's determined that somebody didn't receive constitutionally adequate notice, then the only solutions available are either to obtain a deed or a release of the lien, or institute an action to quiet title. Okay, so let's talk a little bit now about the homeowner's policy. Note, this is different from an owner's policy. So before this type of policy became available, the definition of extended coverage was the removal of standard exceptions from a policy. Alta homeowners policies have many different names, and it's sort of marketed under those names by different underwriters. So some call it what it is, the Alta homeowners policy. First American calls it the Eagle policy. Other underwriters call it the Advantage policy. But it's all basically the same. So these are only available for 1 to 4 family residential properties and condominiums where the land is legally described as being part of a recorded plat or other government authorized map. So basically it's got to be in a platted subdivision or a condominium. It gives you all the protection of Alta's other policies, but adds a lot of additional valuable coverage. Now, it may be, depending upon the property, that the title agent will want to inspect the property. And it does require the receipt of a specific affidavit from the seller. The policy is not available for vacant land or new construction. So as of the Fidelity January 2015 rate filing, this is what the premiums look like. for the homeowner's policy. So we'll give you a comparison. So for a $300,000 policy, you know, your basic owner's policy with no credits, for $300,000, you're looking at about $1399.25. For, you know, the expanded, you're looking at $1570.73. So generally, the cost is about 12.5% more for a homeowner's policy than just the owner's policy. It gives buyers and lenders coverage for future events affecting title, which they have not caused or created. So let's take a look at some of this expanded coverage. Forgery. So it gives you protection over the life of your ownership of the property if somebody forges your name to a deed in an attempt to sell it or create a lien on your property.
Question.
Yes.
Are there any RESPA issues if a title firm will give the enhanced policy for not the higher price if they get both sides of the transaction?
You wonder what title company that is. I don't know if there are RESPA issues, but there certainly are state of Michigan licensing issues.
Okay.
At least according to, from what I've heard, about 20 other title companies that have filed complaints at the state of Michigan.
Okay.
We've not been one of them, but I've heard other title companies that have. Let's see, it'll protect you against an easement by prescription. So if somebody in the future claims to have the right to use part of your land as an easement because they've been doing so for a certain period of time, it'll protect you against future encroachment. Say, you know, your neighbor builds a shed and it encroaches onto your land. Coverage is provided if title to your property becomes clouded because a recorded document mistakenly has a legal description that includes your land. You'd be surprised how often this happens, where we see mortgages with an incorrect legal description, and all of a sudden somebody goes to sell their house and it's got a mortgage given by somebody else. Pre-existing violations of restrictions, which somebody later on tries to have you correct or remove. And this coverage applies even if the restrictions are an exception in the policy. Building permit violations from previous owners. Say somebody, built an addition and never pulled a building permit, and all of a sudden the city realizes that and they come after you. The coverage gives you up to $25,000 of insurance if you're forced to remove or correct structures that were built without a building permit. Now there is a small deductible of 1% or $5,000, whichever is less of the policy amount. Zoning violations, it gives coverage for that, again, subject to a small deductible. Encroachment of boundary walls. So say there's a wall or a fence that encroaches onto a neighbor's property. It'll protect you against a claim of adverse possession. It provides you with coverage if you transfer your property to a living trust. It also gives you basically coverage for a temporary rental if you can't occupy your home due to a covered claim. It also automatically increases the amount of insurance 10% a year for the first 5 years. So the coverage is increased to a maximum of 150% of the original purchase price. So this, gives, your buyers automatic protection due to an increase in value. what to request one, and if the seller objects, offer to pay the difference in the premium. So let's talk about surveys a little bit. We touched on them earlier. So the purpose of a survey is to legally describe the property. And why that's important is because for a deed to be legally effective, it has to have a sufficient and unambiguous description of the property. You should always confirm that there are identical legal descriptions in the deed, survey, and the title commitment. They also set boundaries of a property relative to adjacent properties, and a survey may disclose encroachments or even gaps between properties. It will disclose the means of access to the property, whether it's a public street or a private easement. And if access is by way of an easement, the easement should be surveyed also. I mean, we've seen cases where an easement doesn't quite meet the public road. So we've had clients have to go back and contact the owners of that property to amend the easements to make sure that they do actually touch the public road. It may disclose unrecorded matters such as private roads, public utilities, and improvements that encroach on the property. So there's different types of surveys. The one you see most common in commercial deals is what's known as an ALTA NSPS survey. It meets the standards set forth by the American Land Title Association and the National Society of Professional Surveyors. Now, details of an ALTA survey can vary. Some items are optional, but it typically will show all mathematical dimensions of a meets and bounds description, as we had talked about earlier, both measured and previously of record. It'll show public rights-of-way and means of access. It will show all recorded easements, identification for recorded plats or master deeds, and including information of adjacent properties. It'll show the location and dimension of all improvements, and that includes not only buildings, but signs, parking spaces, things like that. It'll show setback and height requirements and location of utilities that serve or are located on the property, and also all fences. Another type of survey is what's known as a certified survey. And this is one that's prepared for the purpose of dividing a parcel into separate parcels, and then it gets recorded with the Register of Deeds. Next, which is what many of you have probably seen, is what's known as a mortgage survey. It's commonly used in residential transactions. It has, I guess, a more limited utility than an ALTA NSPS, because it typically only shows the boundaries of the property and location of any improvements. A boundary survey that just discloses the boundaries of land, doesn't show any of the improvements. And then another is what's known as a topographic survey. And in addition to the boundaries and improvements, it'll also depict the elevation of the property. So it'll show changes in elevation to the property, which it shows by using contour lines. Then an as-built survey. This is a survey that's done after completion of construction on the property, and it just basically confirms that the building was built where it was supposed to be built. So when you review a survey, you should review the legal description. Compare the written legal description with the drawing that's on the survey. You should have a point of ending that's the same as the point of beginning. You should confirm that the legal description in the survey is the same as the legal in the title insurance commitment. Review the drawing in detail. In particular, pay attention to the encroachment of improvements from the adjoining property onto yours, or from yours onto adjoining properties. Also look for encroachment of improvements into easements. Confirm that easements that are listed in your title commitment are actually shown on the survey, and vice versa. You know, if there's easements that are showing in the survey, they better be on the title commitment. If you do have an Alta NSPS survey, confirm that improvements are in compliance with setbacks. You'll want to confirm that there's access to a public road, again, either directly or through an easement. And the survey should include the surveyor's contact information, a legend for all the symbols, and it should also show a north arrow. Typically, title companies are going to see a survey that's dated within the last 6 months, and it should be certified as true and correct to the lender, the buyer, the title insurance company. One thing to consider is that if you have or can get an old survey of the property, the original surveyor may be able to update it for a lower cost. So that's it. What I will do is leave this screen up here for a few minutes. If anybody would like a copy of the presentation, feel free to send me an email, and I will email a copy of the presentation to you. So do we have any questions?
Yeah, I have a question.
Okay.
We've got a client that's got about 140 rental homes in Wayne County. And we've got a commitment, and where we got it from, they don't seem to have any interest in helping us through the 119,000 pages of this policy. So my question is, do different agencies do more or less, or help or ignore in terms of all the things that have to be done on the requirements page, especially when you're dealing with things like, like matters with improvements that are no longer there, easements that have been long closed decades ago, and so on and so forth?
Good question. I think it depends on the title company. It's going to depend upon their knowledge and experience, right? Listen, there's a lot of very good title companies out there. There's a lot of new title companies out there who, may have hired people with not as much experience. So it may be not so much an unwillingness to help as it is not knowing what to do, right?
Okay.
I can't really speak to why, another title company is or isn't doing something in particular. It sounds like quite a project, I'll tell you that. I'm guessing a lot of these properties had previously been tax foreclosed.
A couple of them.
Oh, okay, just a couple of them.
Yeah. No, not surprisingly, not the bulk of them. Although a few of them we found out had been on a demolition list. So, which of course is a moving target itself.
Yeah. No, and that's tough to deal with right now because, most of the underwriters say that those list pendants for demolition don't go away. Unlike a list pendants for, say, just regular, civil litigation expires after 3 years. So that requires going down to what I call BSeed, which is a department at the city of Detroit, and getting a release of the list pendants. Well, they're not working in the office right now.
Right.
And now I have an email address for one of their employees, but how quickly I'm going to be able to get a release of the list pendants, I have no idea.
Right. Okay. I figured it was probably a agency to agency thing in terms of how much help we could get.
Yeah, I think that most title agents are willing to help. I would assume that most agents are willing to help as long as the seller's willing to to pitch in as well. You know what I mean?
Right. Yep. Can you put your email address back up?
Sure. Give me 1 second. Here.
Thank you.
You got it?
I have a question. At what point do you ask for enhanced, should you always ask for an enhanced policy?
Put it this way. I think given the benefits of it, I think it's wise for a buyer to ask for it. At the very least, for a realtor, I think it's a good idea to educate your buyers about it. I mean, if they decide, I don't want to pay the extra 12.5%, I'm really tight on my budget, that's fine. But at least they're going to hear you talking about this and say, wow, my realtor really knows a lot about this stuff. I've never heard about this before. And, I'm glad that they recommended it to me.
Okay. And you have to ask that right up front when you first start, like.
I think you're best to get it into the purchase agreement and have that discussion with the listing agent.
Okay.
Because, put it this way, in some areas of the state, it's basically very common. I mean, I know in some counties on the west side of the state, if you're refinancing your mortgage, that lender wants the homeowner's loan policy.
Okay.
I can tell you firsthand from litigating a couple of fence line disputes and an adverse possession dispute, it's good to have those policies.
Okay, thanks.
Okay. Any other questions? All right. Well, I thank you for attending. Hopefully next time, next year when we do this, we'll be able to do this in person.